Hello guys, there was a second court hearing between NewJeans and ADOR, and the two sides failed to reach a settlement. NewJeans side declared that trust is completely broken, while ADOR left room for agreements as they have done in the past. So let's do a detailed breakdown of what happened in court and what it means for the future of this group. Okay. The article that I'm about to show you, the title says, NewJeans versus ADOR, no settlements, ongoing tension, court left puzzled. Written by Yoon Hae-young from Sports Today. The legal dispute between NewJeans and ADOR over their exclusive contracts continues without a settlement in sight. On the morning of June 5th, the Seoul Central District Court Civil Agreement Division 41, presiding judge Jung Hwae-il, had the second hearing for the lawsuit filed by ADOR against NewJeans, seeking confirmation of the validity of their exclusive contracts. As with the first hearing, the NewJeans members did not attend, although, according to other Korean media agency, NewJeans fans, some bunnies, were there in front of the court building, waiting for the members who never showed up. Meanwhile, 5 lawyers from NewJeans side, Sejong lawyers, attended, whereas for ADOR, 6 lawyers from Kim Hae-jang attended. The two sides clashed over the contents and submission of evidence throughout the hearing, with the judge occasionally interjecting with questions and expressing confusion. When asked about the possibility of a settlement, NewJeans' legal team stated, the trust has been so deeply broken that reconciliation is no longer possible. 신뢰 관계가 이미 너무 파괴돼서 되돌아올 수 없다고 생각한다. While ADOR side responded, whether through this lawsuit or the injunction case, once the court reaches a conclusion, we believe a settlement will be easier to reach. That's pretty interesting. All right, this article is divided into 3 parts. Part 1, court said submitting evidence is ADOR's responsibility. Let's find out what that means. The court first summarized the arguments made in written statements. According to the summary, ADOR claims that the defendants keep changing their reasons for terminating the contract, defendants meaning NewJeans, suggesting that the termination was forced and the reasons were made up afterward. NewJeans, on the other hand, argues that after HYBE executives seized management control, ADOR failed to fulfill its duty to protect and support the members, justifying the termination, and further insists that the specific grounds for termination are legitimate. Okay. The court asked ADOR to clarify several points. First, whether a board resolution was passed to delegate all matters of the exclusive contract, except duration and payment terms, to Heejin. 이사회를 개최, 이 사건 전속 계약 이사회를 개최, 계약 기간, 정상 요건을 제외한 나머지 사안을 민희진에게 위임하기로 결정한 사실이 있는지, and whether the company consulted or informed the members about how Heejin's dismissal would affect their activities, whether any protective measures, for example, related to image rights, were taken proactively before the members requested them. As for NewJeans' allegations of a media smear campaign, the judge noted that the claim was emotionally charged and said the court wouldn't weigh in unless formal evidence was submitted. So it seems like the NewJeans side has claimed that HYBE used the media as for smear campaigns against them. But the court said, well, okay, I see what you're saying, but I think you're being too emotional there, so bring us specific evidence, right? NewJeans lawyers, NewJeans lawyers emphasize fulfilling management obligation isn't about simply replacing Heejin with another producer. Anyone can provide a list of producers. That's not why we signed an exclusive contract. They also demanded that ADOR discloses details of any meetings or negotiations with producer Hitchhiker. Okay. To this, the judge said that's up to the plaintiff to submit And if they don't, wouldn't that ultimately work in the defendant's favor? So that's where the court or the judge sounded confused, according to this journalist. All right, so here's a summary. During the hearing, the court reviewed written arguments from both sides. In the beginning, ADOR claimed NewJeans kept changing their reasons for terminating the contract, implying the termination was unjustified and the reasons were made up after the fact. Right? NewJeans argued that termination was valid because ADOR, under HYBE's control, failed to fulfill its duty to protect the members. And the court asked ADOR to clarify several points, including whether NewJeans had been delegated key decisions through a board resolution and whether the company had communicated with the members about the impact of her dismissal. Now, regarding NewJeans' allegation of a media smear campaign, the court said it wouldn't comment due to the emotional nature of the claim and advised that evidence be submitted instead. Now, and when NewJeans questioned whether ADOR fulfilled its management obligations by simply introducing another producer, the court responded that it's up to ADOR to decide what evidence to submit, and if they don't, it could end up benefiting NewJeans. And I looked into who Hitchhiker is, and it seems like his producer under Fit Records and HYBE IM. So I think I've heard about this guy, but anyways, it seems like ADOR had contacted Hitchhiker for a potential producing job for NewJeans after NewJeans. All right, so that was part one, and also about the smear campaign allegations. Well, according to NewJeans fans, NewJeans and there are a lot of journalists who write positive articles, in favor of NewJeans and NewJeans. So I'm not sure what kinds of allegations that they were trying to, raise against ADOR or HYBE smear campaign. All right. Next part: Kakao evidence disputes in NewJeans versus Source Music case. All right, what is this about? The court also addressed ADOR's request to subpoena documents, stating the request was related to Source Music. Previously, on May 30th, at the Seoul Western District Court during a damages suit filed by Source Music against former ADOR CEO NewJeans, NewJeans' team argued that certain KakaoTalk messages submitted as evidence were obtained illegally and should be inadmissible, asking for a closed hearing. The court responded that it would review how the messages were required before deciding whether they could be admitted, and Source Music's planned presentation was postponed. And remember, we covered this a couple days ago, right? And I made a video about it. And at the time, so NewJeans' legal team argued that the KakaoTalk messages were illegally obtained, but Source Music countered that the messages were not secretly obtained, but rather collected through company devices. And I think this article also talks about it. NewJeans' side weighed in, saying, "We have raised concerns with the Western District Court that the Source Music evidence may be illegally obtained. The court acknowledged the possibility and said it would assess the issue later. Even if the subpoena is fulfilled, it may be more efficient to wait until the other case is resolved." So once again, they're trying to delay the case as much as possible. ADOR responded, "That matter is for the other court to decide, but the audit was legitimate. The files came from a company-owned computer, and the individual who provided them consented. It's not accurate to label this as legally collected evidence." And we have talked about that as well, right? Source Music also said that they claimed that prior employee consents had been given. They also cited precedent. Similar evidence had already been accepted in a separate but related case. And at the time, the judge did not immediately reject or admit the evidence. Instead, they chose to withhold the ruling on the KakaoTalk evidence for now and proceed with other matters in open court and prohibit either party from referring to or quoting the disputed messages during the day's session. Now, this case is pretty different from this one, but NewJeans' side is trying to make the connections, right? NewJeans' side also said Actually, where is it? Yeah. The judge clarified, even if the documents are sent, that alone doesn't make them valid evidence. The plaintiff would need to review and select what to submit, right? Plaintiff referring to ADOR. NewJeans side said, we just thought it would be more efficient if things were sorted out over there first. To which ADOR responded, the judge's explanation is correct. All right, so here's a summary for this part. The court discussed whether to accept Kakao messages as evidence in connection to the separate lawsuit between NewJeans and Source Music. ADOR requested a document submission related to Source Music. In a previous hearing, NewJeans' legal team argued that the messages were obtained legally and requested a closed trial, right? The court in that case postponed the decision on whether the evidence would be admissible. NewJeans' side also expressed concern that the evidence may have been unlawfully collected and said it would be more efficient to wait for the Western District Court's ruling before proceeding. Why? I mean, of course, we all know that NewJeans and NewJeans are one and the same in these cases. They're sharing the same lawyers, Sejong Law Firm and Sejong Lawyers. But why are they worried about NewJeans' Kakao messages? That's, I don't know. I wonder at this point what is in those messages. Are they even worse than those ones that we have already seen? I'm very curious. ADOR countered that the files come from a company-owned computer with full consent from the person who provided them and therefore cannot be considered illegally obtained. And yes, we also talked about that. Where is it? There's, allegedly, NewJeans even sent those Kakao messages through a company device. So, the court clarified that even if the documents are received, they're not automatically accepted as evidence. They must be selected and submitted by the plaintiff, plaintiff meaning ADOR. So both sides acknowledge this position. So we'll see whether we'll be able to have access to those Kakao messages. We meaning the public. All right, next part. Dispute over next hearing date. Sounds like someone's trying to delay the process once again. The court said it would schedule the next hearing sometime in July or August. ADOR emphasized, since this is a matter concerning active exclusive contracts, we need a legal decision as soon as possible for both parties' sake. And that makes sense. I mean, I've said last week or something, this is a lose-lose situation for ADOR and NewJeans. Only NewJeans is the one who benefit from these cases being delayed as much as possible. And by now, NewJeans must have done all kinds of activities for their own sake, meeting a lot of fans, raising revenue, but what? Yeah, Both sides agreed on July 24th as the next date. The court offered them 30 minutes in total to present their arguments. Now, here's a pretty interesting part. NewJeans' team responded that 30 minutes wouldn't be enough to deliver their presentation and asked to push the presentation to the following hearing. All right. The court countered by extending the presentation time to 1 hour and instructed them to proceed with it on July 24th. Yeah, so that was what I just read. All right, so ADOR wants a fast ruling to research authority while the contract is still active. NewJeans is slowing things down to buy time and build a stronger case. The court is trying to strike a balance, but it's clearly drawing limits to how much delay it will tolerate, right? Because the court initially proposed setting the next hearing for July or August, but ADOR emphasized the urgency, noting that the exclusive contract is still active. NewJeans must be working right now. They should be working. They should be doing what they like and also contributing to their agency's business. And a legal ruling is needed promptly. And in the end, both sides agreed on July 24th as the next hearing date. And the court offered 30 minutes total for both parties to present their arguments, but since NewJeans' side made a request, the court extended the time to 1 hour. And that reminded me of this interesting comment made by one of the self-claimed NewJeans fan who who has criticized and who has dissed the PT files presentation slides made by Kim and Jong, ADOR's lawyers, saying, what did they say? First of all, PPT aesthetics are so bad, and Kim and Jong doesn't even teach the basics of PPT wording. Whatever. And then, meanwhile, they have heavily praised Sejong's PPT slides. Matches the title and subtitle description exactly. Thumbs up! The Kim and Jong PT is at the level of those who don't even know the basics. I won't talk about the aesthetics because I think whatever. But what was the result? Yeah, 11-0, 11-0. Like, aesthetics of presentation files don't matter in court. But I wonder what kinds of beautiful PPT slides they will come up with in the next hearing that they will supposedly deliver for 1 hour. All right, so that was the article. Although I found this segment from another article saying this. Finally, the court once again asked both sides about the possibility of a settlement. The NewJeans side said at the previous hearing that they weren't open to a settlement, the judge noted. But from the court's perspective, we still encourage it, even if just out of hope. NewJeans' legal team replied, the trust has already completely broken down. We have crossed a point of no return. 돌아올 수 없는 강을 건넜다. Literally translating, we have crossed the river with no point of return. ADOR, however, left the door open. If the court delivers a decision, whether on the main case or the injunction, we believe a settlement could happen easily afterward. So that was pretty interesting. The ending is the summary of what has happened before. Previously, Seoul Central District Court's Civil Division 52 approved ADOR's request for indirect compulsory enforcement. Under that order, if NewJeans engages in entertainment activities without ADOR's consent, they must pay 1 billion Korean won per violation. And I have talked about that last week. The third hearing is scheduled for July 24th at 4 p.m. All right. But it's interesting how, NewJeans' reference to a point of no return, shows a fundamental collapse of trust from their perspective, not just a contract dispute. So their team is clearly drawing a hard line to justify a full separation, likely hoping the court recognizes the gravity of that breakdown. Meanwhile, ADOR's strategy seems more reactive based on their comments. They're not ruling out settlements, but only after getting favorable legal leverage, so to say. And this implies that they're trying to pressure NewJeans into negotiating from a weaker position once the court rules on key issues like injunctions or damages. But of course, the court is caught in the middle, is pushing for a compromise, and they're recognizing this imbalance, and then they seem aware that true reconciliation is unlikely. Yet, they still hope to avoid a drawn-out legal battle. And it's interesting how they worded their phrase. 재판부 입장에서 아쉬운 마음에 권유한다. And I wonder who they're 아쉬워 for. So what it's saying is that they believe that a better outcome could be possible, instead of like NewJeans' side saying that nope, we have crossed the point of no return, no settlement is possible. But I kind of feel like, at this point, due to the injunction case, there's very little likelihood of NewJeans' side winning, and probably the court knows it as well. So they're, suggesting reconciliation or settlement, but NewJeans' side is saying a big no. And I kind of feel like usually lawyers try to reach for the settlements if it's possible. But depending on your clients, sometimes it's not possible, right? Especially if your clients are very adamant about what they want to do, i.e., NewJeans in this case. So we'll have to see what happens. Let's wait for July 24th for the third court hearing. And yeah, I'll be looking forward to that beautiful PPT slides to be delivered by Heejin law firms for 1 hour. And hopefully some Korean media agency will report on those slides, show us the actual slides. All right. And then, yeah, once again, I'm super curious about what kind of Kakao messages will be included in these evidence submitted by Source Music. We'll have to see. Okay, as always, if you have any comments to share, please, share them through your comments in the comment section. And as always, let's stay positive, respectful, and classy. All right, how many days are left till BTS members are back? D6. Wait. Oh, what is going on? Oh, it says D5. It just looks like D6, but I think it says 5. It's just the color purple being too dark. D5, D6, and D16 until June 21st. Peace and love. Bye-bye.